Hello, everybody. My name is Darren Draper. I apologize I'm not able to make it with you in person or live tonight. I'm working at the USET conference, and so I'm a bit detained, but I'm with you in spirit. The case that I'm going to discuss tonight is Wagenblast v. Odessa, which is an interesting case. It went before the Supreme Court of Washington State back in 1988. The facts of the course, or the case, are that several Washington state school districts joined together and decided to create a policy that would require students who wanted to participate in athletic and other extracurricular activities that they would have to sign a release form that would release the school districts from any sort of liability of negligence. The school districts were hoping for zero liability as far as accidents and things like that might take place during the activities. And the case explored this question of, can school districts require students and their parents to sign these written releases which release the districts from any kind of consequences of future negligence that might take place before the students will be allowed to participate in the activities. And so the holding of the course was, or the holding of the court was that no, school districts, they owe a duty to its students to make sure that they're taking care of their facilities and they anticipate reasonably foreseeable dangers and take precautions to protect the children while students are participating in these activities. And that this duty extends to interscholastic sports. And so ultimately the rationale for this was that these releases that districts wanted the students and their parents to sign are invalid and that they actually go against public policy. Another thing that the courts discussed in connection with this case was the role of the legislature in determining what public policy is. Because there had been precedents in the past of the legislature enacting laws that come into this realm. For example, in 1869, they determined that school districts could be made liable for acts of negligence. And there are several other instances of that, but ultimately, since territorial days, the state legislature of Washington they had generally followed a policy of holding school districts accountable for their negligence. And so the decision of the courts that day, back in 1988, was in accordance with that policy.